Welcome to This Explainer. Today, we're unpacking a pretty intense yet rigorously fact-checked piece of source material. We're going to conduct a forensic test of bureaucratic accountability. The document we're analyzing reconstructs a hypothetical, but entirely evidence-based legal cross-examination of a high-level government official. Our goal here isn't to take any political sides. Instead, we want to impartially examine exactly how civilian administrative structures interact with mass human rights violations. And we'll be using the historical context of the 1990s Punjab counterinsurgency to do it. Okay, let's just dive right in. 2,097. It's a devastating number, right? This figure really anchors the sheer scale of the tragedy we're looking at today. It represents the confirmed, officially recognized number of illegal cremations in the Amritsar district between 1992 and 1996. We're not talking about battlefield casualties here. We're talking about bodies processed straight through a municipal system, completely bypassing proper identification or any sort of legal inquiry. Which brings us to a really chilling editorial principle from our source text, before the word, the cremation ground. It sets the stage for our entire examination today because it asks a fundamental question. How exactly does a sophisticated, legally bound civilian administration either enable or just ignore human rights violations on such a massive scale? I mean, how does the paperwork just keep flowing while thousands of people disappear? All right, so let's get into the architecture of impunity, specifically looking at how the magistracy oversees the police. To really understand this dynamic, we need to look at the guy sitting at the absolute top of the district's administrative pyramid, K.B.S. Sidhu. He was the deputy commissioner and district magistrate of Amritsar during this exact 4-year period. And what's really interesting here is his background. Sidhu wasn't some low-level, easily intimidated bureaucrat. Actually, he was an elite AIR2 selectee of the Indian Administrative Service. That means he ranked second in the entire nation during his selection process. He commanded vast, statutory, supervisory authority over the district police. He was incredibly capable, highly intelligent. Moving on to the arsenal of authority. Basically, the statutory tools that were actually available to stop these violations. So you've got this highly capable official in charge while 2,097 illegal cremations are happening. A super common defense for civil administrators is, well, we simply didn't have the power to stop the police. But our source material completely dismantles that excuse. The district magistrate actually held a powerful statutory arsenal. He had Section 97, allowing him to issue search warrants for any place where a person is wrongfully confined. He had Section 144, for urgent danger. But absolutely crucially, he had Section 176(1). Notice the statute uses the mandatory word shall regarding magisterial inquiries into custodial deaths. It wasn't a suggestion, it was a strict legal requirement. And yet, the source notes a glaring absence of these mandatory inquiries for the unidentified bodies being cremated. To really measure this level of inaction, our source does something brilliant. It holds the administration's conduct up to an international civil rights standard known as deliberate indifference. This actually originates from a U.S. Department of Justice framework, and it asks a very simple question. Did a supervisory official know of a substantial risk of a constitutional violation, and did they consciously disregard that risk by failing to act? Keep that in mind as we go forward. Next up is what we can call the illusion of ignorance, where the text challenges that classic bureaucratic defense of just not knowing. Okay, so if an official has the power, and the standard of accountability is crystal clear, their next line of defense is almost always, well, I just didn't know it was happening. Let's see how the text tackles this. In the reconstructed cross-examination, the official's defense boils down to this one quote: "I relied on the information provided through the established system." The administration basically claims they just accepted the police's own reporting chain. A chain which, by the way, conveniently labeled thousands of bodies, including 1,238 completely unidentified people, as mere militant casualties from legitimate encounters. But hold on, there's a massive flaw in that logic. What if the established system itself is the one committing and concealing the crimes? Here is the most crucial point. A civilian human rights investigator named Jaswant Singh Khalra literally went to the cremation grounds and just read the municipal firewood vouchers. By reading 482 of these firewood vouchers, he exposed the massive scale of the illegal cremations. I mean, a civilian with a notebook figured out what the absolute top magistrate in the district claimed he didn't know. So, yeah, the established system was clearly compromised. And get this, it wasn't just one guy with a notebook. Despite claiming they had no idea, the administration received extensive, highly documented notice of the crisis. Human Rights Watch published a detailed report in 1994 explicitly naming specific villages and officers. Amnesty International documented it. Local civil liberties groups filed detailed field reports. There was even a massive surge of habeas corpus petitions hitting the High Court. The administration was absolutely saturated with warnings.
This leads us to the stark contrast between action and inaction, basically examining where the administration actually put its energy.
To really wrap our heads around this accountability void, just look at this sharp juxtaposition. On the left, we've got the Galiara Project. It was a major urban planning and beautification initiative around the Golden Temple. The district magistrate was highly engaged here, coordinating with central ministries, consulting religious bodies, leaving a massive continuous paper trail. But then, look on the right. When the human rights investigator Jaswant Singh Khalra was abducted by the police, the administration's response was practically non-existent. They passed the complaint back to the very police accused of taking him, claimed they marked an inquiry to an assistant magistrate, and left absolutely zero documentary trace. It's wild. Now we're going to look at a really critical, harrowing window. The fatal 49 days during Jaswant Singh Khalra's illegal detention. This is essentially the ticking clock of his confinement, happening right under the district magistrate's nose. This timeline maps the catastrophic cost of administrative delay. On September 6, 1995, Khalra was abducted in broad daylight. The very next day, a formal police report was filed in the district headquarters. By September 12th, his wife had taken it a step further and filed a habeas corpus petition directly with the Supreme Court of India. The district magistrate had a 49-day window, 49 days to deploy his Section 97 search warrant powers to find a man illegally held in his own district. But he didn't. On October 27th, Khalra was murdered. When our source text reconstructs a cross-examination about this absolutely critical 49-day period, the administrative defense is, well, it's shockingly thin. The reconstructed official response is simply, the matter was referred to the ADM for inquiry, appropriate communication was made with the police. That's it. No urgent warrants, no personal inspections, just standard, vague, bureaucratic routing. And the source text systematically tears this defense apart. I mean, think about it. If an inquiry was actually marked, why did it never seemingly reach SSP Sandhu, the specific police chief who was actively holding Khalra? And why on earth could the administration not produce a single document, not one single piece of paper to show the Supreme Court they were actively looking for him? An inquiry that fails to question the prime suspect and produces literally zero paperwork is not an inquiry. It's just the illusion of one. Finally, let's look at the accountability void, focusing on the magistrate's exit and the administrative distance he created. So let's look at the immediate aftermath. How does the architect of this district's bureaucracy actually exit the situation? On August 11, 1996, barely 9 months after Khalra was murdered, and just as the Supreme Court and Central Bureau of Investigation probes were really heating up, the district magistrate departed. He left for a highly prestigious, comfortable foreign training program at the University of Manchester in the UK. In later writings, he even expressed a sense of relief at leaving the posting. But look at the reality he left in his wake. We're talking about a district with 2,097 confirmed illegal cremations. He left the families of 1,238 unidentified persons desperately waiting for answers. He left behind a murdered human rights investigator. And incredibly, he left behind an absolute void of administrative paperwork. Even his own daily diary for those fatal 49 days went missing, meaning there was no documentation of any real response to the crisis. As we wrap up this explainer, the forensic breakdown we've gone through forces us to ask one final, deeply provocative question about the true cost of bureaucratic impunity. When a powerful civilian magistrate knows the system is broken, yet routes complaints of disappearances directly back to the very police causing them, does relying on the police to investigate themselves constitute administrative innocence, or is it in fact deliberate complicity? Thanks for joining us today, and remember to always keep questioning the systems around you.